Hello, my name is Patricia Niebauer, and I am a North Carolina licensed attorney, and I practice at Robbins May & Rich here in Pinehurst, North Carolina. Our firm assists First Health in legal matters, and one of our partners, John May, serves as general counsel for First Health. Today, we are here to show you how to fill out a healthcare power of attorney and an advance directive for natural death, which is also known as a living will. While these forms can take different shapes, today we're here to walk you through the form that is provided free of cost on the North Carolina Secretary of State website. You can go to the website and print out the healthcare power of attorney and the living will, and we'll show you how to fill it out. The importance of having a healthcare power of attorney cannot be overstated. It is a document that allows you to designate a trusted friend or family member to make healthcare decisions on your behalf in the event that you are unable to communicate those on your own behalf. In addition, it also allows you to avoid having a court guardianship proceeding to establish who's going to make those decisions. It also allows you to designate who will make those decisions on your behalf and to direct whether or not you will have life-prolonging measures discontinued under certain circumstances. We are providing this video for information purposes only, and this video is not intended to form an attorney-client relationship. Should you have any specific questions on what these documents say or how to fill them out, please consult with an attorney. And now we will turn to what you need to do in order to complete this document. And now we're going to turn and walk through the different parts of the healthcare power of attorney. Section 1 allows you to designate who you're going to place as an agent for the power of attorney. You can name several individuals and you can list them in order of preference. Your medical providers are always going to contact the first person listed, and if they're not and that way you can nominate who you feel is appropriate to serve in that capacity. Section 2 of the document states that the healthcare power of attorney will not come into effect until a physician directs that you are not able to make medical decisions for yourself. Therefore, the document allows you to designate a specific physician to make that determination of whether or not you're capable of making medical decisions on your behalf. If you choose to leave this section blank, which is perfectly fine, it will be whomever the attending physician or medical provider is at the time who will make the determination as to whether or not the healthcare power of attorney needs to be enacted. Section 3 of the document states that you may revoke this document at any time, and you can do a new one or simply revoke it by notifying your chosen healthcare agents of your decision to revoke the healthcare power of attorney, and also notifying your physicians of this decision. It's good practice to go ahead and destroy any copies of any old documents that you've revoked so that there's no confusion about whether or not they apply. Section 4 of the document states all the different things that your healthcare agent can do on your behalf if you're incapacitated, and this includes things such as admitting you to the hospital or to a nursing home and assisted living facility if necessary. They can consent to medical treatment. They can consent to the withdrawal of medical treatment in certain circumstances, and they can also receive medical information in order to help them make those decisions about your health care. Section 5 allows you to provide a little bit more guidance to your healthcare agent as to what circumstances do you want them to act on your behalf, or if you have any specific instructions for your agent. In particular, Section 5A allows you to determine whether or not your healthcare agent has the power to withhold or discontinue artificial nutrition and hydration. And again, you can initial this choice and you can specify under which circumstances you're comfortable with them withdrawing or limiting artificial nutrition and hydration. Section 5B allows you to provide just specific information to your agents about what you want them to do when making healthcare decisions on your behalf. You don't have to fill in anything, but if you feel like you want to express your wishes on a particular situation, you can certainly write it in here as a further guidance for them. Section 5C allows you to specify whether you have any limitations regarding your mental health treatment. And Section 5D allows you to specify whether or not you have filled out a separate mental health treatment power of attorney. This is a separate form that is offered also on the Secretary of State website, and you can download it and fill it out if you so like. Section 5E allows you to write in instructions regarding things that you want to happen after your death, such as your funeral and burial arrangements. If you wanted to be cremated, or you had a specific location where you wanted to be buried, or what you want done with your remains, you can go ahead and write those in as guidance for your agent. Section 6 allows you to state whether you would like your agent to donate your organs or donate your body for study after your death. Section 7 states that if for any reason it became necessary to appoint a guardian to watch over your person, it is your wish that the court would appoint the individuals you've designated in Section 1 as your guardians. Section 8 states that your physicians and your healthcare agent can rely on the instructions that you've set forth in the power of attorney, and that there's no liability to them for following your instructions. Section 9 covers a range of provisions, including the fact that this document revokes any prior executed powers of attorney, that it's intended to be governed under North Carolina law, but that it's also intended to be effective in whatever jurisdiction you find yourself in. Finally, once you finish filling out all these sections, you will need to sign this document before a notary public and 2 unrelated witnesses. And these unrelated witnesses cannot be employees of your healthcare facility. So you will need to find 2 independent witnesses to witness it and a notary. Failure to follow these execution requirements of the document may render the document invalid. So again, I urge you to go ahead and fill it out and comply with the execution requirements. And finally, I would encourage you to share this document not only with your designated healthcare agents, but also with your medical providers and your hospital. First Health of the Carolina offers the opportunity to fax in your documents to them. If you go to their website, there will be a link that will show you a form that you can download and fill out and fax your documents in using that cover sheet. The Advance Directive for Natural Death, also known as Living Will, allows you to designate or inform your healthcare providers under which circumstances you direct the withdrawal or withholding of life-prolonging measures. Section 1 of the document allows you to choose under which circumstances the living will apply. Medical circumstance number 1 is in the case of an incurable or terminal illness. And an example that I give my clients is stage 4 cancer or some other similar condition which is at its end stage. Option 2, the second medical circumstance under which it can apply, is if you're unconscious or in a vegetative state and to a high degree of medical certainty, this condition is not reversible. So you're in a coma and unlikely to ever come out of it. Option 3 is if you were to have advanced dementia or some sort of cognitive condition that is not reversible. A classic example of this is Alzheimer's disease. So you can choose all of these circumstances or whichever one you feel comfortable, but the ones that you initial will be the circumstances under which the living will and life-prolonging measures will be discontinued if you so choose. Section 2 of the living will allows you to choose whether your doctors or medical staff have the option of following your instructions or whether it's mandatory that they follow your instructions if you are in one of the medical conditions that you initialed in Section 1. So if you give your doctors the options, they're going to be the ones deciding whether or not to follow the living will. If you choose for it to be mandatory, then they will follow your instructions under all those medical circumstances that you've chosen. Section 3 allows you to state whether or not you want to receive artificial nutrition or hydration, regardless of whether life-prolonging measures are discontinued. So under Section 3, you can still choose to receive artificial nutrition and hydration, even if any other life-prolonging measure is discontinued. You could also choose just to receive artificial hydration or just to receive artificial nutrition. Again, it's up to you. If you don't initial any of these choices, artificial nutrition and hydration will also be discontinued. Section 4 of the Living Will requests and asks that your physicians and medical providers would continue to keep you as pain-free and clean and comfortable as possible, even if all other life-prolonging measures are discontinued. Section 5 is an affirmation that you understand what you are signing, that you are directing that life-prolonging measures would be discontinued under these circumstances that you have chosen. Section 6 allows you to state whether your designated healthcare agent, which you have appointed under the healthcare power of attorney, if they have the power to override your living will. So you can choose whether or not they have to follow it or whether or not they have discretion to exercise a decision about life-prolonging measures. Section 7 affirms that your medical providers should follow your healthcare directive as you've stated in this document. Section 9 says that you may revoke this living will at any time by either destroying the document and providing notice to your healthcare agents and medical providers, or by communicating your intent to revoke to your physician. We come to the conclusion of the living will, which, the same as the healthcare power of attorney, must be signed before two unrelated witnesses and a notary. Again, two unrelated witnesses who must not be employed by your healthcare facility, so they have to be independent parties, and a notary public. And lastly, we strongly encourage you to share your healthcare wishes with your family and friends and your doctors so that they have a clear understanding of what your wishes are regarding healthcare decisions or end-of-life decisions and continuing or discontinuing life-prolonging measures. Finally, as we finish the document, you will need to sign both the healthcare power of attorney and the living will before two unrelated witnesses and a notary public. Failure to follow these execution instructions could mean that the document would be considered invalid and therefore your wishes would not be carried through. We encourage you to share a copy of your signed documents with your healthcare agents that you've selected, your medical providers, and your local hospital. First Health has a link on their website that will allow you to download a fax cover sheet and fax these documents to them, and that way those documents will already be on file with First Health. Lastly, if you should have any questions regarding these documents or any concerns, please discuss them with your attorney.